So I guess none of us were surprised when a week or so back the defence team did a filing where they wanted to close pre-trial proceedings to the public. It was a given, I guess. When you look at all the motions that have been filed by Ms. Burden, aka Lizzie Burden, I shouldn't say that, it was a given that she was going to pull that stunt. Thankfully, the media is fighting back. So what I'm just going to go through today is a document which is a objection from multiple media companies to this motion, which has now been filed with the courts, which should hopefully mean that the motion to seal the pre-trial proceedings will be thrown out. So I am going to read through it because I think it's worth giving it the attention it deserves. I think we should definitely be grateful that the media are super interested in this case. So on that note, let's just jump in. So first of all, we have 4 different media companies here that are weighing in on this. 5 different media companies. I missed the Orlando Sentinel. Meaning that between them, they have plenty of resources to fund any legal battles throughout this trial in terms of fighting against motions like this one. This also gives us a heads up as to where we can expect to see footage of the trial as it occurs. So this document, the media interveners' opposition to defendant's motion for closure of all pre-trial proceedings. Non-parties and interveners, WFTV TV, WKMG TV, Fox 35 Orlando, WESH TV and Orlando Sentinel, collectively the media interveners, respectfully move to intervene in this case for the limited purpose of opposing defendant's motion for closure of all pre-trial proceedings, filed on 18th of February 2025, in brackets, the motion. Background: in March of 2024, the state of Florida charged Stephen Stearns, defendant, with 60 criminal counts, including battery of a child under 12, L and L, can't read any of this, can I? And unlawful possession of materials depicting SPC, sparking significant public interest. I'll just mention I will put this document for you into my Patreon account if you want to go over and grab a copy of it for yourself. Anyone who's not aware, my Patreon is free, documents are free, so all you have to do is you sign up. You only need an email account to sign up, and then you can access every document that I dump in there for you. In a misguided response to the heightened public interest in this case, defendant now asks the court to enter an order closing all pre-trial proceedings in this cause to the press and public. Motion at 1, to justify the expansive remedy he seeks, defendant alleges that unless the court operates in complete secrecy from now on until the trial, he will forfeit his right to a fair trial. Motion at 1.3. I love that they've said basically a misguided response to heightened public interest, because it's so true. It's also just because his defence lawyer is a little bit too overzealous. The media interveners are news organisations that have reported and continue to report on the instant matter. Each relies as part of its news gathering processes on multiple sources, including judicial records and proceedings. The media interveners have standing to challenge defendant's attempt to close judicial proceedings, and then you have it's citing precedent. argument. More than 75 years ago, the United States Supreme Court recognised that what transpires in the courtroom is public property. And in the decades since, Florida has steadfastly ensured openness and transparency amongst all three branches of government. Honestly, the lawyer writing this should have Lizzie's job, because they do a far better job of writing intelligent motions, that's for sure. Florida has been in the forefront of promoting open government. Okay, so we'll just skip through all these precedents. Bottom paragraph. Florida courts have cited many reasons for the state's staunch posture of judicial transparency. For starters, the Florida Supreme Court explained that openness is basic to our form of government, and public trials are essential to the judicial system's credibility in a free society. Yet the right to open courts not only ensures that the public is kept fully informed of judicial proceedings, but it also serves the additional role of providing essential protections for litigants. As the Florida Supreme Court has emphasised, transparency is essential to testimonial trustworthiness. And heck, don't we know that when we look at the Delphi case? Because it produces in the witness's mind a disinclination to falsify by stimulating an instinctive responsibility to public opinion and inducing fear of exposure of falsehoods. Okay, that's not what I meant in terms of Delphi, but yeah, that's a good point. An analogous effect is produced upon counsel and, just as importantly, the court. So it's basically saying, if it's basically being watched by the public, then people are more likely to act ethically and behave. In acting under the public gaze, they are more strongly moved to a strict conscientiousness in the performance of duty. Explaining that public access to judicial proceedings is important to the public's understanding of the function and operation of the judicial process and the criminal justice system, and may operate as a curb on prosecutorial or judicial misconduct. And let's not forget now that in this digital world, it's even more important for this transparency to exist, because it's not just now people from the United States that are following cases like this. You have people like myself who are here in Australia and are so emotionally invested in this case that I would be really, really pissed if this was kept under wraps. And also people like myself, as you know from when I've been discussing various motions and stuff, there's a lot that I don't know about Florida law and Florida statute. So to have proceedings there where it's all visible, it just makes it easier for everyone to understand. As the Florida Supreme Court summarised, public access to the courts is an important part of the criminal justice system, as it promotes free discussion of governmental affairs in imparting a more complete understanding to the public of the judicial system. Such access gives the assurance that the proceedings were conducted fairly to all concerned. Ding, 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 ding. That's the big issue right now with Delphi. There are people who are still convinced, having heard extremely biased reporting, and you still have people shouting out innocence for Richard Allen because they were only privy to biased reporting and not to the actual proceedings in the court. Aside from any beneficial consequences which flow from having open courts, the people have a right to know what occurs in the courts. The Supreme Court of the United States has noted repeatedly that a trial is a public event. What transpires in the courtroom is public property. Public access also serves as a check on corrupt practices by exposing the judicial process to public scrutiny and protects the rights of the accused to a fair trial. Finally, because participating lawyers, witnesses and judges know their conduct will be subject to public scrutiny, it is fair to conclude that they will be more conscientious in the performance of their roles. Totally agree. Thus, as explained time and again by Florida courts, open and transparent judicial proceedings increase public confidence in the judicial process, enhance the credibility, legitimacy and integrity of the courts, and protect the rights of all entities involved by actively opposing biases, false or inconsistent testimony, due process violations, improper prosecutorial conduct, and errant legal action. Based on these public policy considerations, when a trial court is faced with a request to close a courtroom, it should begin its consideration with the assumption that a pre-trial hearing be conducted in open court unless those seeking closure carry their burden to demonstrate a strict and inescapable necessity for closure. And I would imagine that would occur if we are talking about cases involving minors. So a lot of cases where minors have unalived people, they are then closed for the protection of the minor. This doesn't fall into that category at all. To that end, this court must apply the three-part test established by the Florida Supreme Court. Sorry, thanks to our friend Lizzie, I just have an aversion to actually quoting the names of the different precedents. But let's move on. A closure of a proceeding necessary to prevent a serious and imminent threat to the administration of justice. No alternatives other than a change of venue would protect the defendant's right to a fair trial, and closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish the purpose. The moving party must satisfy each of these elements by a preponderance of the evidence. Mere allegations will not suffice. Those seeking closure have the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary. The presumption being that a pretrial hearing should be an open one. Yet, as shown below, defendant has failed to produce sufficient evidence to satisfy any of the three elements, much less all of them. Defendant has not established that closure is necessary to prevent a serious and imminent threat to his fair trial rights. Beyond defendant's repeated insistence that his rights are threatened, the only facts the defence presents to justify his request for closure are that A. potentially inadmissible evidence may arise pursuant to defendant's anticipated pre-trial motions, and B. this case has attracted and will continue to attract significant media attention. Motion at 1-2. Neither of these facts, however, justifies a finding that closure is necessary to prevent a serious and imminent threat to defendant's fair trial rights. You could potentially apply those to just about any case that has gained media attention, couldn't you? This is really well laid out, and it's easy to read, easy to understand. It's so far from being like the tedious stuff that Ms. Burden has been putting out. 1. The potential inadmissibility of evidence does not require closure of pre-trial proceedings. Defendant asserts that he plans to file multiple pre-trial motions to suppress and exclude evidence. Yep, let's try 70-something. See motion at 2. In some instances, he states this will involve evidence which may later be found to be inadmissible. Included in these discussions of Mr. Stern's evidence will be Mr. Stern's statements to the police, the medical examiner's findings, and potentially discussions on evidence related to statements from minor children. Id. Florida law is clear, however, that the admissibility of evidence is not probative of whether such evidence is accessible to the public. And face it, we know, we've seen all this evidence anyway. The need to examine evidence for its admissibility is not one of the prongs set forth in Lewis and is not sufficient to justify closure. So I'm not going to read the actual names of the precedents, but just what they are about. The inadmissibility of evidence has no bearing on whether evidence is or is not public record. And then performing a Lewis analysis and rendering inadmissible evidence available to public. Oh, sorry, I didn't need to read that bit. For example, in State versus Cosma, the court suppressed a defendant's statement that included potentially damaging admissions. The court, however, refused to seal the statement, stressing that even where pre-trial publicity includes publication of inadmissible evidence or confessions, a defendant can still receive a fair trial. In fact, the Lewis test itself arose in the context of a suppression hearing for the confession of a 14-year-old M suspect, explaining that a carefully controlled suppression hearing can itself be conducted in open court without creating any prejudice, because the issues concern not so much the contents of a confession, but the circumstances under which the prosecution obtained this material. The Florida Supreme Court determined that suppression hearings are of great moment beyond their importance to the outcome of the prosecution. That's really bizarre grammar. I've read that over in my head several times, and I'm really not sure of the exact meaning of that. Are of great moment beyond their importance to the outcome of the prosecution. In other words, they're important in terms of making sure prosecution is fair, but it's still really, really weird. Let me know your interpretation of that, please. Okay, this may provide an explanation. A motion to suppress involves allegations of misconduct by police and prosecution that raise constitutional issues. Such allegations, although they may prove to be unfounded, are of importance to the public as well as to the defendants. The searches and interrogations that such hearings evaluate do not take place in public. The suppression hearing is the only opportunity that the public has to learn about police and prosecutorial conduct. In other words, it keeps police and prosecutors honest. It is important that a decision of the trial judge on a motion to suppress be made on the basis of evidence and argument offered in open court, so that all who care to see or read about the case may evaluate for themselves the propriety of the exclusion. So yeah, it's about transparency to keep everyone honest. That is why Florida courts regularly reject requests to close suppression hearings. Yay. Thus, defendants' position that pretrial proceedings featuring potentially inadmissible evidence should be closed fails purely as a matter of law. In addition, the defence has presented no facts to explain how, in the context of this case, any of the potential matters for consideration he enumerates in this motion would practically jeopardise the defendant's fair trial rights. They are handing Lizzie's ass to her on a tray right now. Denying a defendant's motion under Lewis in part because the defendant failed to show how the public's knowledge of potentially inadmissible evidence would threaten his fair rights. See, that is like a precedent. See State v. Montez. Okay. Sorry, a little bit of mumbling there. 2. Pre-trial publicity is not a sufficient basis for closure of court proceedings. Heck, look at Laurie Vallow, look at bloody Casey Anthony, where does it end? Defendant argues that he cannot receive a fair trial in Osceola County because the instant case has attracted significant media attention. See motion at 2.3. This argument fails because defendant has not and cannot show that the jury pool is tainted or that the media attention has otherwise prejudiced his fair trial rights. First, defendant's argument posits the specious assumption that the entire prospective jury pool within a county of more than 400,000 residents is vulnerable to irreparable tainting. But with so many prospective jurors in Osceola County, the statistical odds for an impartial veneer are highly favourable. See Skilling versus United States. Given this large diverse pool of potential jurors, the suggestion that 12 impartial individuals could not be impanelled is hard to sustain. Yay. As another court explained, impanelling a jury in a county with hundreds of thousands of residents essentially precludes the type of showing required by the strict three-part Lewis test. Noting further that a significant number of the public does not retain what is disseminated by the media or simply does not read newspapers or watch television. As a result, the feared impact on the fair trial rights of criminal defendants often does not occur, even in matters that have received extensive media coverage. Second, even if all potential jurors in Osceola County remembered what they read, heard or saw in any media about this case, closure would remain unwarranted because publicity, which is all defendant has alleged here, is not synonymous with prejudice, as the Supreme Court explained. Prominence does not necessarily produce prejudice, and juror impartiality, we have reiterated, does not require ignorance. Jurors are not required to be totally ignorant of the facts and issues involved. Scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. Every case of public interest is almost as a matter of necessity brought to the attention of all the intelligent people in the vicinity, and scarcely any one can be found among those best fitted for jurors who has not read or heard of it, and who has some impression or some opinion in respect to its merits. A presumption of prejudice or decisions indicate attends only the extreme case. Qualified jurors need not, however, be totally ignorant of the facts and issues involved. To hold the mere existence of any preconceived notion as to guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. And, it's so true. I mean, of course, people may have heard of the case, but that's not going to mean that they're going to come into it with a decision made. Sure, any one of us called as a juror may be disqualified because we have basically spent the last 12 months looking at this case. But how many members of the public are like that? Okay, and we have another one here saying pre-trial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. I think we can see that they are arguing this really well, so I will stick to the body of this argument now rather than skipping off to the side with all these various little things that they've quoted. To be sure, pre-trial publicity is in topical criminal cases is normal and expected, and media attention alone has never been a sufficient basis to justify closure of court proceedings. And then we have well, I'll quote this one just because, noting that even massive pretrial publicity about a case is not enough to show a serious and imminent threat to the administration of justice or the denial of fair rights. Because defendant cannot illustrate the threshold Lewis element, that of serious and imminent threat to his fair trial rights, the court should deny the motion. B. Defendant has not established that alternatives to closure are insufficient to protect his fair trial rights. The second element of the Lewis test requires the movement to show, by a preponderance of evidence, in other words, more than not, that no alternatives are available other than change of venue, which would protect a defendant's right to a fair trial. Lewis 4:26. As explained above, defendant has not explained how his right to a fair trial is or could be jeopardised, but to the extent that his rights are implicated, he cannot demonstrate why an alternative short of the drastic measure he proposes would not suffice. Here, defendant has presented the court with no facts. This seems to be Lizzie's thing, doesn't it? She doesn't present facts to suggest that an alternative to closure would not cure any alleged ills. For example, Lewis suggests voir dire, I know, I get it wrong every time, as an alternative to closure. And defendant has stated no facts to suggest why the process of voir dire could not be used here to screen out potential jurors who cannot set aside any biases related to their exposure to reporting about this case. Perfect point. Closing it pre-trial is pointless because that's the whole point of voir dire. Voir dire? I'm so sorry. Lewis also states that preemptory challenges are an alternative to closure. The defendant has not explained why preemptory challenges could not be used here to strike any potential juror who displays or suggests partiality during voir dire. Moreover, Lewis also lists admonition of the jury as yet another alternative to closure. And there is no reason why, if impaneled jurors indicated a familiarity with prior reporting of these proceedings, the jurors would ignore an admonition by the court that their verdict can be based only on the evidence presented during the trial. It goes back to what I was saying before in previous videos about how Ms. Burden seems to have this idea in her head that jurors are just all morons. Okay, C. Defendant has not established the efficacy and narrow tailoring of the requested closure. Here, defendant requests the indiscriminate closure of all pretrial proceedings, yet the third prong of Lewis requires the movement to prove that closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. The Lewis court explained that when prejudicial information already has been made public, there would be little justification for closing a pretrial hearing in order to prevent only the disclosure of details which had already been publicised. Here, as defendant recognises significant details about the matter are already publicly disseminated, that's for sure, so defendant must show that potential public knowledge about hitherto unknown information will deprive him of his right to a fair trial. A burden he has not even attempted to bear. There's very little information that isn't already out there, really. And then we have several precedents which basically say exactly that. As to the third prong of the Lewis test, the defendant failed to show that granting his motion would be effective in protecting against the perceived harm, since much of this information has already been made public. So there is a precedent right there. There's little justification for granting the motion. You have this again and again. So again, down the bottom here, closure at this point will have little, if any, effect on the potential jury pool. So they've quoted multiple cases where basically there was a tension beforehand and the move to close proceedings was thrown out. Rather than a hindrance to fair trial rights, heightened public attention only increases the need for the appearance of fairness, so essential to public confidence in the system. Oh, heck yeah. To be sure, publicity is vital to an open and accountable judicial system. As former Supreme Court Chief Justice Berger explained, without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. That is why any closure must be narrowly tailored to protect defendants' fair trial rights. Yet here, defendant seeks closure of all pre-trial proceedings, regardless of the issues presented or even knowing what might be disclosed in them. Thus, in sum, because this matter has already received significant publicity, and because nothing could be less narrowly tailored than the unqualified closure of all pre-trial proceedings, defendant also fails to satisfy the third Lewis prong, and because defendant cannot satisfy a single element of the Lewis test, the court should deny the defendant's motion in its entirety. Conclusion: before entertaining the draconian remedy of closing a public courtroom, Florida law demands an evidentiary showing that a defendant's rights are seriously and imminently threatened, and that nothing short of a narrowly tailored closure will protect those rights. As shown above, defendant has failed to satisfy any of the three required elements to justify closure, much less all three. For these reasons, the media interveners respectfully request that the court deny defendant's closure motion. And then looking at who the lawyer is for this is a Rachel E. Fugate. And I have to say, she has definitely shown her prowess. I feel really confident that there will be no closures in terms of this case. I think we will be able to see every element of this case from woe to go. From go to woe. Sorry. I like that this document it's so clear and concise. It's nothing at all like the gobbledygook that we've looked at from Ms. Burden. It seems like Ms. Burden is outclassed everywhere. The state's already handed her ass in a few motions, and now we have this lawyer for the media handing her ass. It really highlights her inadequacies as a lawyer. Hopefully that won't be something that is used in appellate court. Maybe she's just really bad at writing motions. Or maybe it's just that whole copy and paste thing that she does with her motions. Who knows? But I definitely feel confident now that they're not going to close this case to the public. So I'm glad I went through this entire document, that's for sure. So that brings us to the end of this video. I hope this has allayed a few people's concerns in terms of the motion that was filed a week or so back to close proceedings. I think we can be extremely confident that that is just not going to happen. This is actually the first of two videos for today. I hadn't had this one on my list of jobs to do, and I have the other one queued up to start working on. So you can expect that several hours away, but you can expect that today also. So on that note, thanks for listening. If you are new to my channel, please subscribe. I'm really keen to build my channel up some more. Also, you can help me out by hitting the like button and leaving a comment below. Does this allow you to feel confident that the case won't be closed to the public? And what's your opinion between this lawyer versus our friend Lizzie Burden? I think there is definitely a distinct difference in their capabilities, but I'd be really keen to hear your opinions. And feel free to vent at me over my mispronunciation of voir dire. Did I get it right that time? I'm trying really hard. I don't know why my brain goes to mush every time I try and say it. Who knows? Anyway, on that note, thanks for listening, and I will catch you in the next one.